Good morning from Washington, D.C., everybody, and good afternoon to Austria. Welcome to our webinar, US Tariff Update, US Trade Policies 2026, Supreme Court Ruling and Impact on US Tariff Policy. My name is Thomas Moschig, and I'm the Trade Commissioner and Head of Advantage Austria here in Washington. And it's my pleasure today to guide you through today's info session. Our offices in Washington and Atlanta, we cover topics around trade policy and tariffs, and this is why today we have the honor to host you on this informative session on latest developments. Before we start, a few housekeeping rules. First of all, I wanted to say that this webinar is being recorded, as you know it from our previous webinars. Second, the recording itself and today's slides by our expert will be shared with all the registered participants after this event. And third, you can ask questions. I think that's a crucial information today at any time using the chat window. Due to the limited time we'll have today, we'll focus on the most relevant questions during the live question and answer sessions. So please submit questions which may be relevant to other participants as well, and please like or vote for questions which are interesting for you as well. That way you help us understand which questions are more relevant to the audience, and that helps us prioritize. We'll try to address also the unanswered questions with our tariff expert after the webinar, so rest assured that you will get one answer either during the show or after the show. Yes, before we proceed, let me just quickly draw your attention to our own webpage, the info point for US tariffs, in German Zoll info point, a webpage in German language, which has the objective to inform Austrian enterprises on the most relevant US trade policy and tariff news. Since March 2025, the US government has imposed, updated, corrected, and removed a series of import tariffs, as you know, and we try to keep you up to date on this very page. You can access it through the QR code visible on this slide, or our live audience can also access it through the link provided by my dear colleagues in the chat window. So now let's get into the technical details of today's webinar. When dealing with US trade policy, you will come across many acronyms, different abbreviations, and I therefore allowed myself to prepare a little cheat sheet slide where I ask you or invite you to either take a screenshot or note down some of these acronyms and explanations which you don't know for a better understanding of today's discussion. Let's just quickly go through them. Let's start with the easy ones. The past days have been full of news regarding IEEPA, the International Emergency Economic Powers Act. This is the act which has been used by the president illegally, as the Supreme Court found, to be used as a legal basis for most reciprocal tariffs. But IEEPA is not the only legal basis for tariffs. The sections like 122, 232, or 301 of the Trade Act of 1974 are also further legal US legal basis for the US president to impose new tariffs without the consultation of the Congress, at least until no higher court decides differently. Section 122 and 301 will be the doubtful stars of today's webinar, as we will hear later from our speaker. And I would also like to say one word about Section 232. This is the basis for the sectoral tariffs. Austria is heavily impacted from the sectoral tariffs based on 232, as they target, for instance, steel, aluminum, and copper, as well as its derivatives, and tariffs up to 50% apply on these goods. Also important to know is the BIS, which is the Bureau of Industry and Security. This is a federal agency that can impose tariff restrictions based on national security concerns. So bespoke in Section 232 is sort of at home, if you want, at BIS, the Bureau of Industry and Security. You will hear the acronym CBP a lot. This is the Customs and Border Protection. This is the agency that collects the tariffs, classifies goods, and enforces at the US border. CSMS is a very important source, primary source for you. This is the Cargo Systems Messaging Service. Here, importers can obtain information on tariff rate changes, new tariff actions, classification rulings, and implementation guidance for trade remedies. So here you can also find useful information as this webpage is, of course, up to date. The MFN, known to all of you probably, is the standard non-preferential tariff rate applied to WTO members. This is the baseline before additional tariffs or trade preferences. The DOJ is the Department of Justice. No further explanation needed here, probably. The SCOTUS is the acronym for the Supreme Court of the United States, the ultimate jurisdiction over constitutional and federal law. The CAFC is the Court of Appeals for the Federal Circuit. This is the second instance under the Supreme Court. We'll hear about that as well today. And the CIT is the Court of International Trade. This is the first instance when we talk about trial courts for customs and trade disputes. And last but not least, the USTR is the United States Trade Representative, or the Bureau of the United States Representative. This is the office that initiates Section 301 tariff investigations, and this is the office that plays a pivotal role also in trade agreements with foreign countries and recommends tariff actions to the US president. The trade representative's name is Ambassador Jamieson Greer, and I can spoil that you will hear this name more often in soon future in the news. Good. So this is a little help for understanding this today's discussion a little bit better. I hope that this is helpful for you. So let's get started with a quick recap what happened the last 10 days. Obviously, many of you followed this, but just to give everybody an overview before we start with the contents, let's just see what happened. February 20th, the Supreme Court issued a 6-3 ruling that tariffs imposed by the presidents under IEEPA law are unlawful. This was a much awaited and yet major decision, which triggered a very fast political response. On the very same day, a couple of hours later, 2 executive orders and 1 proclamation followed by the president's office, which terminated the collection of the IEEPA tariffs effective with February 24th of last week, and continued the suspension of the duty-free de minimis treatment for all countries for shipments under $800. Remember that until August 29th, it was possible for retailers to dispatch goods commercially without any additional goods with the value under $800 without any additional tariff charge. And this is not possible as of August 29th and was prolonged last week. In addition, a proclamation of a new 10% surcharge was imposed to address what the administration calls fundamental international payment problems based on Section 122 of the Trade Act of 1974. 1 day later, a still very furious US president announced via his most popular social media platform that 15% will be effective immediately. 15% tariff rate will be effective immediately. This message has also been widespread across Europe and also across Austria. Also, Austrian media has distributed this message. But up to this point and up to as we speak, there is no legal basis for the 15%. So as of now, still the 10% are valid because of the legal basis we're having at the moment. And finally, February 24th, that was last week, a key moment and a turning point in the US tariff regime era where all the measures which we just talked about came into force. So ever since, we have a new tariff legislation and a tariff regime in place. And all of that I'd like to discuss today with our tariff and trade expert. I'm very happy that we have Nicole Bivenson today in our webinar. Nicole, thank you for joining us. I'd quickly like to introduce you as our leading international trade expert and managing principal operating committee at Sandler, Travis and Rosenberg here in Washington, D.C. STR, Sandler, Travis and Rosenberg, is the world's largest dedicated international trade and customs law firm. And yeah, Nicole herself is an absolute expert and a trusted lawyer for us. She has nearly 40 years of experience in government, public affairs, and lobbying. So she and her wonderful team are constantly supporting us when tackling questions, corporate questions from Austria regarding the current tariff regime. Nicole, thank you very much for being on the webinar today, for taking your time. We are very curious to hear from firsthand what's your opinion on the latest developments and what's to watch out for as an Austrian company.
Great. Thanks so much, Thomas, and welcome everyone. It's my pleasure to have the opportunity to speak to you again. So I'm going to pick up where Thomas left off. Next. First, I want to say that despite the fact that I am giving this presentation from a law firm, this is not legal advice. If you need legal advice, then call me and we can give you that independently so we can protect the attorney-client privilege. The other thing I want to stress is that the information I am sharing right now is only as good as the moment that it comes out of my mouth. This is a very volatile, highly changing environment. We are not sure one day to the next, even 1 hour to the next, if there may be changes. So if you take this presentation, and I'm sure Thomas will be sharing it and posting it, making it available for other folks, when they review it, they need to know that this is a good basis, but that there could be some changes. So always check to see what the most recent information is. Next. What does the Supreme Court ruling do? So I think we all know that it only made one decision, and that decision was, were the tariffs legal or illegal? That's the only decision that was in the Supreme Court. They ruled they are illegal. Any tariffs today or tomorrow that are being imposed under IEEPA are illegal. It is going to remand the case or send back the case to the lower courts. And the other thing it clarified is that there were two courts that were used. So we have the Court of International Trade, which deals with tariffs. That's the one we work in all the time. Then you have the district court, which is, cases go on all the time. Because there was a challenge in both the district court and in the Court of International Trade, they both advanced to the Supreme Court. The Supreme Court came out and said, any future discussions or issues go through the Court of International Trade, not through the district court. So it's just establishing the court of jurisdiction. It's establishing that the lower courts are going to make any further decisions, and it said tariffs are illegal. Next. What's important, I think, to remember is what the Supreme Court case does not do. It does not decide whether or how refunds should be issued. That was not the issue before the Supreme Court. So that is going to be passed back down to the lower courts. In the dissenting opinion, Justice Kavanaugh said that this could be a mess. That's not true. It is just not true. U.S. Customs has the ability, at the push of a button, to run a data query in their database, and they can identify every single entry, every single importer, the exact amount of tariffs that were paid, and as of February the 6th, the CBP Customs mandated that all companies had to have electronic funds transfer capabilities. So they can do the run, identify the importers, identify the amount, calculate the interest, and then push a button and automatically transfer that money into your account. It could be that easy, but we'll see. Next. It also did not make any claims or statements as to whether or not the president could use other tariff authorities, such as sections 122, 201, 232, 301, or 338 to replace them. In the majority opinion by Chief Justice Roberts, he said that there's other statutes which offer opportunities to the president to impose tariffs, and that's really the best route to go. Next. It did not determine whether or not the suspension of de minimis is legal or illegal, because in the executive order that was issued establishing the IEEPA tariffs on April the 2nd was also a provision to revoke the treatment of duty-free for any shipments $800 or less per person per day. So it revoked that treatment. This case did not rule on that. Next. So what happened as a result? On the 20th, on the day that the decision was issued, the president took 3 actions. He issued an executive order that's told all agencies they must stop collecting duties by February the 24th. Why the 24th and not the 20th? Because there's programming in the system that needs to be done by customs in order to stop collecting the duties, and they needed time to effectuate that change. He issued an executive order stating that nothing in the Supreme Court changes the current suspension of de minimis. And then he issued a presidential proclamation invoking Section 122 that is used to address fundamental balance of payment problems, imposing a 10% tariff effective, amazingly, the same day or 1 second after the IEEPA tariffs go away. Next. With respect to de minimis, right now, de minimis is still suspended, but there is a provision in place for international mail shipments or postal shipments. So under the IEEPA tariffs, you had a choice of either, for your international post shipment, either paying the IEEPA tariffs or paying a flat fee per package based on what the IEEPA tariff was for the country of origin. That option for a flat fee no longer exists under the Section 122 tariffs. So if you're shipping a package internationally, you're going to have to pay a 10% tariff on the value of whatever that product is. You also have to make sure that you know the country of origin, because that has to be declared to customs when it comes in. And this is going to, this replaces whatever the IEEPA tariff that were in place before for those international shipments. Next. Now, there is a case in the courts still pending on the issue of whether or not the president could suspend the de minimis provision. It's called the Detroit Axle case. On February the 26th, so just last week, the court had put a stay or a pause on that case pending the outcome of the Supreme Court case. The Supreme Court case has been decided, and so Detroit Axle has asked the courts, like, okay, the Supreme Court decision is done, let's go. We want you to address our case as soon as possible. The reason that they're asking the courts to move and to move quickly is because they're saying they have suffered irreparable harm. The one thing to consider, though, and I just don't know where it's going to land, we're watching it closely, is that between the time that the president suspended the 321 de minimis exception, Congress passed a law that said by July 1st, 2027, there will no longer be a de minimis provision. So the question is, will the Detroit Axle continue in this case to try to restore the de minimis provision? And if they do restore it, it's only going to be for 18 months, perhaps 17 months, because it's going to go away next year anyway. we're watching it closely just to see what happens on that. So I don't know if you have a business that relied on some of that de minimis, just watch it because it could change. Next. So the other proclamation was the establishment of the 122 tariffs. So let's be clear, there is only a 10% tariff on all countries, on all products, except for the exception list. That's what's in place today. There is no 15% in place. We need to always remember that social media is not policy. Until we see some sort of an amendment to this presidential proclamation, that tariff will only be 10%. It is still possible, but right now, 10%. It was effective at 12:01 a.m. on February the 24th. It will last for 150 days or until July 24th, 2026. Now, that could be extended by Congress. Next. There are some exceptions. I mentioned these. Recall in the IEEPA tariffs, there was an annex, Annex 2, and it had a long list of products that were not going to be subject to the tariffs. Many of those were agricultural products that aren't available here, or certain critical minerals and rare earth elements, things like that. Some civil aviation. That list is encompassed. But I think one of the key things that, in addition to recognize in this list of exception, are aerospace products. And I think that there are a lot that come out of your country. They were previously only exempt for certain countries. Now they're exempt for all countries. So, you know, that exemption remains in place. Next. There's further exemptions. Anything that's currently covered under a Section 232 tariff does not have to pay the 10%. So if you're paying 25% tariff on imported lumber, or you would not stack that 10% on top of that. So you would only pay the 232 tariff. You would not pay the 122 tariff. If you are producing a product that is the country of origin is or qualifies under the USMCA, it is exempt. If you're producing an apparel product that is manufactured in a Central America or Dominican Republic free trade partner country, the Costa Rica, DR, El Salvador, Guatemala, Honduras, Nicaragua, it's exempt if it's textiles and apparel. If you are importing any types of donations or informational materials, such as books, etc., those are exempt. If you're importing anything under Chapter 98, the Chapter 98 of the Harmonized Tariff Schedule of the United States, if you use the Chapter 98 for the importation, that is also exempted. Next. For foreign trade zone goods, if you use a foreign trade zone, when you bring the product into the United States, when you admit it into the foreign trade zone, you have to claim privileged foreign status. What that means is that on the date in which you admit the goods to the FTZ, it locks in whatever tariff rate is in place. So if today you would enter the goods into the FTZ, not enter, you would admit, you have to admit goods into the FTZ, you would lock in 10%. But let's say that I don't withdraw those goods until June. And in June, no, I'm sorry, August, because that's after the July 24th date. So in August, I withdraw the goods from the foreign trade zone. Despite the fact that on the date which I withdraw those goods, that 122 tariff is gone, because I had to claim privileged foreign status, PFS, I would have to pay the 10% that was in place when I admitted the goods into the zone. Some of you may use duty drawback where you bring products into the United States, maybe you transform them, manufacture them, maybe you are trying to sell them in the United States, but it's just not selling, and you have a subsidiary in Canada or back in Europe, and so you want to ship it back or ship it out of the United States, you can draw back the duties that you paid. There's nothing in here that prohibits you from getting those 122 tariffs back, so that's a good thing. Next. The question is whether or not Section 122 is lawful and how long it will last. The law says you can impose tariffs up to 15% for 150 days unless, and Congress can't extend that amount. The question is, will Congress extend it? And will the president, and I think the answer is, I don't think so. I think that in an election year, remember, this is an election year in the US for all 435 members of the House of Representatives and 33 members of the Senate. So a lot of people up for re-election this year, and they're not going to want to have this additional tariff on their constituents. So I don't think that it would be extended. However, could the president issue a second 122? There's nothing in the law that prevents the president from imposing these tariffs for 150 days, lifting it, and then the next day reimposing them. That could happen. Or we could see a situation where the president puts them in place, Congress does not extend, and the president says, sue me, take me to court. That has been a pattern of this administration. I could see that happening. So you may have to go to court anyway. And then the question becomes one of whether or not a trade deficit qualifies, because that's, if you listen to the words that the president used, he talked about because of these big trade deficits, we have to use Section 122. He did refer to a balance of payments a couple of times, but the question is a balance of payments issue the same as a trade deficit? For you economists out there, I know you're going, no, they are nothing the same. They are not alike. What's even more telling is the IMF, the International Monetary Fund, issued its annual report, and in its analysis of the United States, it explicitly said there is no balance of payment problems. Some economists argue because we have a floating currency, we can't have a balance of payment problem. You know, that really took care of it. And you have to include services when you're looking at balance of payments and issues. And that's a whole different metric to analyze where the United States stands vis-a-vis other countries. Because as you know, with many countries, we have a services surplus. And when you combine services with trade and goods, a lot of times that even that trade deficit swaps from a surplus to, from a deficit to a surplus. Next. Again, is it 10 or 15%? I mentioned that, and as you know, there was a social media posting, Thomas mentioned it, that they would go to 15%. That's not policy. What I understand, and this is, you know, I'm here in Washington, D.C., and the rumors that I've heard are that when the president threatened the 15%, USTR Greer said, no, please hold off. I just negotiated these deals. It's going to blow up the deals. I need to talk to people. And it appears he is negotiating with a lot of the countries to try to make whatever happens under the Section 122 scenario equivalent to that which had been agreed under the IEEPA scenario. So the US is expecting countries to hold to this. You know, it's notable that the UK and EU other countries have not implemented their commitments to the US yet, pending more agreement. So I think that's notable. I also do know that I have heard that the USTR is going back to some of the countries with which we had a framework, but we did not have a text written out, and is asking them to just take a 10% flat, leave it, forget all the negotiations they did, and move on. We're going to see what's going to happen. Next. I think, you know, just to recap, that the tariffs may be challenged at the ITC. I am anticipating some company will come forward in the next few days, or I would say within 2 weeks probably, and file a case challenging the legality. As I mentioned, balance of payments issue is different from a trade deficit, and will probably try to challenge these. It's unlikely that courts would then issue an order to say, you're going to, therefore, they're going to instruct the government to stop collecting duties. So even while the court case is pending, you're going to have to pay the duties. But You could also see a refund if they're successful. As we saw, it took, what, 8 months for that to process through the Supreme Court for the IEEPA, so it could take the same amount of time for Section 122 tariffs. Next. With respect to those trade agreements, I mentioned them. There have been several framework agreements announced for all of these countries listed. You see the ones with the asterisk. Those are the countries that have negotiated text. So they have committed the framework terms to actual texts. Next slide, please. But one of the things that's important is none of these are actually effective. None of the framework agreements are actually effective. You might argue, but wait, Nicole, the US has already implemented some of the terms, the special terms for the EU of a 15% IEEPA cap, inclusive of MFN. And if your MFN is over 15, you had no IEEPA. We implemented some of the terms, but the actual agreements never entered into effect. There are specific provisions related to when an agreement would enter into effect. And it ranges from the day the last notification is given to the United States by the country that they have implemented all the laws, rules, or regulations changes to fulfill the commitments that they made in this agreement, to the day after, 5 days later, 30 days, 60, 90 days. It's all over the place. There's no uniformity as to when the agreements would enter into effect. The other important thing to note is that all of these agreements, except for Cambodia, have language that basically says the other party can impose other tariffs. So, these are that you could put them on for unfair trade practices, for import surges, protect economic or national security, or any other reason that's legal. So, do these countries have a leg to stand on? I would say 7 of them really don't. Cambodia would. I don't know what the agreements were on the framework. It's on because we don't have the text on those. And we know that the EU right now is holding off pending to see the outcome of this. Next. Can the president impose tariffs under other mechanisms? The answer is yes. Section 301, you may be familiar with it. You've heard of it. You know that it has been applied with respect to China. There is a 301 investigation on Brazil right now. There has been 301 investigations on other. The issue is there's no limit on the tariff rate that can be applied, and there's no limit on the duration. So it's, it can be on for, 301s at the end of 4 years, the USTR has to justify to Congress why they are continuing that, the 301 tariffs. But there's no mandate that they have to end at a certain time. Under Section 232, you are all too familiar with that one on steel, aluminum, copper, lumber, autos, auto parts, heavy-duty autos, etc. Those are imposed, though, for national security reasons. They also require an investigation, but there is no rate, there is no limit rate on the rate, nor on the duration that can be in place. Section 201, it's if there is a surge of imports. A lot of times when we see 201 being used when, for example, the US has put an anti-dumping countervailing duty of 100% on all imports of, something from Austria. And suddenly we see this something surging coming in from Romania and from Italy and from the UK. And so in lieu of the domestic industry going back through the lengthy and very costly process of another anti-dumping countervailing duty investigation, they can go to the government and petition them to use 201. And under 201, they can say, you know what? We put controls over here, and it's like squeezing a balloon. The air just moved from this part down to here, so we're going to put the tariffs there. They can have tariffs of 50% or more, but the duties are limited to 8 years. And the ITC conducts the investigation. So we've seen the president use all of these. They've withstood court scrutiny. I think that's to what the president was referring in his State of the Union speech when he said, I can impose tariffs and they're court approved. So I think that's what he's talking about. Next. something that's the 301s. We've already heard that USTR Greer has said that he is going to launch various 301s. You can see the quote there on the different industries. So if you are in any of these, the digital services taxes, there was already an investigation that it was determined that they should be assessed on certain countries. I'm just trying to remember if Austria was one of them. I know Italy was, and maybe France, for their digital services tax. That could pop back up. There could be other reasons, trade and seafood clearly is one, but they're going to do it on an expedited process. Normally, a 301 investigation takes about a year, and we believe that they're going to try to launch some of these and complete the investigation within 150 days. Now, what's important is that when the president used Section 301 on China in his first administration, he did an investigation, came to a conclusion that the damage was $50 billion, and put out a list of goods to be subject to those tariffs to account for that $50 billion. The Chinese retaliated. The president said, I'm going to put tariffs on more products. The Chinese retaliated a second time. The president retaliated a third time. So he added lists 3 and 4A to this list of products subject to tariffs. That was challenged, is being challenged in court. Right now, it's sitting before the Supreme Court. The Supreme Court is going to decide to take on the case or not. But the reason that the big challenge to why this is now still in court is that the administration did not follow another law, which is called the Administrative Procedures Act. That means that when you're doing an investigation and you request public comments and you have a public hearing, which you would have to do in a case of a 301, you have to consider what was said at the hearing and what the comments were. And with the 301 tariffs on China, there were public comments submitted, over 900 comments. 4 days later, they put the tariffs in place. And so the challenge is, how in the world could the U.S. Have considered the 900 comments that were submitted? They did not follow the procedures, therefore it's illegal. So in this instance, we think that the USTR will be more diligent about following procedures, which means they may need more than that 150 days, which tells me that we could see either the Section 122 tariff staying in place beyond the 150 days, or we see where it's on, off a day, back on again. So that's just Nicole's personal opinion. Next. Under the 232s, we've already heard from Undersecretary Kimmett, which I think this is important. He clearly said that any investigations they initiate under Section 232 would be for national security reasons. It would not be in response to the Supreme Court. And again, I believe he is messaging that to the public because otherwise, it would be a huge challenge in the court if they're using 232 to replace IEEPA and they're not doing the national security investigations. We anticipate that the 232s would be accelerated probably 180 days as opposed to normally it's 270 days plus 30 days plus 90 days. We think that it'll be condensed into a much smaller review period. Next. And then there's another big one that we haven't seen before. We have never seen the 122. The other one out there that we have never seen is the Section 338. This is from the 1930 Tariff Act. It's really old. It's what I call the nuclear option because the president has the authority to impose tariffs, to impose tariff rate quotas, and also has the authority to ban the import of goods from certain countries. Not only that, the president has the authority if, as I talked about earlier under Section 201, we see that imports of those types of products surge from a third country, and the president believes that the only reason that the products are surging from this other country is because the measures in place on the first country, he can impose the same measures on this third country. So there's a lot of room there. It's never been used. He could use it after the 150-day runs out. We don't know, but it is something to definitely watch. Next. What about my refunds? I think this is what everyone wants to know. When do I get my refunds? So the Supreme Court notified in its order that these were illegal, that within 32 days, they're going to turn the case over to the Court of Appeals for the Federal Circuit, the CAFC. Next. The Court of International Trade, the first court, they ordered the government, they said these are illegal, and they ordered the government to cease collecting tariffs within 10 days. It was a universal decision. It meant it applied to everyone, not just the plaintiffs in the case, or the people who filed the lawsuit. The Court of Appeals for the Federal Circuit basically voided the CIT's decision because they didn't think it should be applied on a universal basis. And CBP has already stopped collecting these duties. So that was a step to make sure that you can get now a refund. Next. In other cases, the CIT has already decided that the US, in their arguments, has said that they would provide refunds. The CIT has said, we're going to hold you to that. You've said you would provide refunds. The government said, if the Supreme Court determines that these are illegal, we will provide refunds. So there's pretty good assurances that there's going to be refunds. And the DOJ, the Department of Justice, said that they would do it. Now, the next thing is the Court of International Trade has to decide what is the mechanism, or how are these refunds going to be allocated. It could be it could be universal. Everybody gets it. Nobody has to file anything. Nobody has to file a protest. Nobody has to file a lawsuit, or they could do some sort of iteration. We don't know. Next. It could take a little while for the CIT to decide what mechanism or how these refunds are going to be provided. The only instance where we have something similar to this, where the courts decide about the refunds, was about 17 or 18 years ago. I know my former owners of the company, Mr. Sandler, Travis, and Rosenberg, were very involved in bringing a lawsuit against the government for a harbor maintenance tax. And the courts ruled that it was illegal. It took them about 5 months to come up with how the refunds would be provided. What's important is one of the judges, Judge Rastani, was on the harbor maintenance tax, and she is also on the IEEPA case. So she has experience. She's been through this, which makes me think that the mechanism is actually not going to take 5 months, but it'll be much sooner than that. Next. I think what a lot of people saw is immediately after the Supreme Court, a lot of new cases being filed or petitions to the courts. And on the 24th, there was an appeal by the VOS, the case that's at issue here. And it was in the Court of Appeals for the Federal Circuit. And they said, we need to speed this up. You need to, as soon as you get, the CAFC, as soon as you get the case back from the government, you need to remand it and send it back down to the CIT so we can get going on this. The CAFC took the petition and they told the government, Department of Justice, you have until Friday, the 27th, to come back to us. On Friday, the 27th, so just a few days ago, the government argued, no, you should not immediately remand this down to the CIT. You should take 90 days. And the reasons are because we've already said that we're going to provide refunds, so there's no immediate harm, that they're going to be made whole. Because also you can't make this universal. So we learned that they're arguing that it cannot apply to all importers, only applies, whatever this refund is, only applies to VOS, the one plaintiff in the case. And they also said, give 90 days, so maybe Congress will do something. Well, what I thought was funny, that happened on Friday. So Friday afternoon, 4 o'clock or so, we saw what the Department of Justice was arguing. Yesterday, Monday, the CAFC didn't even respond to the Department of Justice. They like we say, they hit them in the head and they said, we're going to remand back to the CIT. So unilaterally, they have already sent the case back to the CIT without even waiting for it to come back from the Supreme Court. So this is huge. This is a very big slap to the Department of Justice, and they're dragging their feet. So we're thinking that it's going to move pretty quickly, and we may see something from the CIT. I would say by the end of this month, maybe. Next. So what do you do now? If you are an importer, if you were the importer of record and you are the one who paid the duties, you need to access your ACE account, which is the automated commercial interface that it's an account, like a bank account basically, that every single importer has with CBP. If you don't have access to it, your broker does, but you should have access to it. You can look at that and see when are your entries going to liquidate? Meaning 314 days from the date that you entered them, they will liquidate. You need to file a protest within 180 days of that date. You need to think about, should I go ahead and file with the Court of International Trade? We are worried now that the Department of Justice is going to appeal whatever decision comes out from the Court of Appeal, from the CIT, and drag its feet. And, the president said for another 2 years. So if they drag it out that long, you only have statutory protection for 2 years from the date on which your first tariffs were paid. So if you were subject to the IEEPA tariffs on March the 3rd, 2025, you have until March the 2nd, 2027 to file a case with the CIT and protect that entry to potentially get a refund. So we have some clients who are like, well, I'm probably going to have to file later. I might as well do it now. So they're doing it now. We have other clients who did not want to file in the Court of International Trade before a Supreme Court decision because they didn't want to appear to be challenging the administration, but now they're willing to file because they're not challenging the administration. The courts have already ruled it. Now they're filing because they're protecting their rights for refunds. Some of our clients said they want to file now because if we flood the courts with a bunch of lawsuits, they're going to be like, whoa, 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 I'm going to do something that prevents you from having to do this. In other words, they want to keep all those thousands and thousands and thousands of lawsuits out of the courts. They want to provide a remedy that just resolves it. So the only other reason that you would file now is if somehow you missed a protest filing deadline. That really hasn't happened yet, but we'll see. Next. Next. Are we going the right way? Next. Keep going again. There you go. The other thing is you are maintaining a database to know when your entries liquidate, when your protest deadline is. The other thing we're suggesting is to make sure for all of those entries, you have all the documents you would need to prove up that you're entitled to those refunds, just in case Customs makes it very difficult and starts requiring all kinds of backup documentation. With respect to unliquidated entries, those entries that are still within that 314-day, normally you have an option to file what is called a post-summary correction, a PSC. And it's just like, okay, I'm going to change whatever I filed because, I made a mistake or the government made a mistake. Normally you can do that. What we're seeing right now is that the CBP is not processing these post-summary corrections. So, you can do that. Sometimes an option for importers is that you ask to extend the date of liquidation until we see what's going to happen. All of our clients who have asked for extensions of liquidation have been denied. So we're not suggesting that you do that any longer. We had initially suggested people do that, but we're not suggesting you seek an extension of liquidation at this point in time because they're not doing anything. Next. What about Congress? Are they going to get involved? Well, we've seen some bills introduced, one in the Senate, and it's partisan. It's all Democrats. It is by the ranking member on the Senate Finance Committee, which has jurisdiction over tariff issues. What it does is it says CBP has to refund everything. They have to do it within 180 days. They have to pay interest. They have to focus on small companies. They have to provide a report every 30 days. So, there's a lot of actions that have to be taken here, but it is partisan. Next, over in the House, we see that there's, in the House, we see that there's been 2 bills so far. There's probably more by the end of today. I mean, they're back in session today, that are aimed at trying to address the refunds. The one I like the most actually is the Relief Act. This one is Bainham and Horsford, both Democrats. And it says you have to provide the refunds within 90 days. And you have to do it automatically. As I said before, that Customs could do this automatically. It's saying you have to. People don't have to file post-summary corrections. They don't have to file protests. They don't have to file in the Court of International Trade. Just do it. So, we'll see what happens. Again, it's Democrats, and they are not in the majority. Then there is another one that takes a little different twist, and that's by Mike Thompson, another Democrat out of California, and he's trying to provide a refund of the tariffs in the form of a tax credit. So every consumer, me, anyone who bought something at the store that was increased because of the tariffs, I get to get a deduction for my income taxes. It's estimated that between $1,300 and $2,000 was every single consumer paid an additional $1,300 to $2,000. Therefore, that might be the amount that I get to get off my taxes. Next. So what's next? What do we need to watch for? We need to watch for the CIT. It could happen, as I said, anytime. The CAFC moved very quickly, and the CIT could do so as well. You need to watch all of your entries. You need to watch the liquidation dates. You need to note your the protest deadlines. We need to watch out for new actions, whether it's 201, 301, 232, 338. We've got to watch for those because they could all be coming out in the next few months. The other thing is we need to watch to see if there's going to be some other legislation or Congress is going to try to intervene more in this process. Next. There's additional resources if you want to. We have, go to our website. We have a lot of informational webinars that you can participate in. We have a trade report that is absolutely free that you can subscribe to. It comes to your email box every morning. There's also a podcast that I host. It's 2 minutes. Well, maybe 3 minutes with the intro and outro. And wherever you get your podcast, you can listen to it and get an update on a daily basis of different trade issues. And that's it. I'll take any questions.
Thank you very much, Nicole. And on that note, I can just support you with what you said about the podcast. I'm a frequent listener to the podcast, so I can recommend everybody as well to tune in for the 2 minutes in trade. That's a very, very interesting podcast on latest developments. Thank you very much, Nicole, for your very interesting presentation. I think a lot of new info in there for us. In the meantime, a couple of questions piled up in the chat. I'll try to go through it as we speak because we don't have that much time left. Maybe I target one of the upvoted questions. There is one which says, who needs to claim the IEEPA charges, the importer or the broker? I think you've touched base on that, but maybe you can explain a little bit more in detail about the importer records.
Right. So whoever was the importer of record is the entity that will get the refund. With respect to who claims it for you, you're probably going to work through your broker or the importer yourself. You can file the protest. So either the broker would file the protest if that's the route that we have to follow, or you can file a protest. We're working with a lot of clients. We've drafted a memo that helps them secure and protect them, the entry, so that not only are you protesting to get the refunds back, but if you made any other mistake, helping you to try to certify that. We're also helping companies file in the Court of International Trade. So, either you as the importer can do it, or you can get your broker to do it.
Is the memo you talked about, is that available? Can we distribute that as well after the webinar?
Sorry, that's IPR.
One of the questions, the question of all questions, I would say, from Austrian side is how are steel and aluminum tariffs calculated? For example, machines with a lot of different materials. That's a question which is like, yeah,
okay,
active and around there for
that's
many
really
months.
getting at the 232s, but it does in some aspects get into the 122s. There is no solid guidance from CBP on how to calculate the value of the steel in a product. There are frequently asked questions. There is an informal memo that's been circulating. However, if you look at the actual verbiage that CBP has issued in their guidance, it says that you have to follow the valuation standards. The valuation standards provide certain leeway as long as you are following those, and in the absence of absolute guidance from CBP, you can use the calculation. You can justify the calculation method that you're using, then that's acceptable. What's important to note is that just as in the IEEPA tariffs, if you have non-steel, aluminum, copper, or whatever value in a product, you will pay the 10% 122 tariff on that value, and then the 232 tariff on the steel, aluminum, or copper value.
122 plus the MFN, I believe, as well, right?
Mm-hmm.
Exactly. So I think we'll have time for maybe one or two more questions. I see that a popular one is here. We have paid these tariffs for some shipments, both export and import. We are both export and import at the same time. The amounts paid are too low for own legal actions. Will the WKO, which is us, prepare some class actions where we can participate, presumably for a certain share of the paid tariff? So that goes out to me and to you, Nicole. I would just answer on our behalf. Advantage Austria, with our legal status in the US, we are not able to sue the host country. We're not able to file a court case. But maybe Nicole, you can leave a comment on class action and for all the companies who are debating just a smaller amount and the smaller refund.
So it's a great question. I had the discussion with the two co-leads of my litigation department yesterday, and what they said is, we've never really seen a class action in the Court of International Trade. And I said, yep. I said, I get that, but this is unprecedented times, unprecedented actions. Why can't we do a class action in the Court of International Trade? And they said, well, we certainly could file a class action suit. Just so that everybody knows, the CIT may not accept it because they've never done a class action. And if the CIT does make a decision, it's possible that they could say, we can't give it to all these people. So the long and short is, I kind of say, if there's a group that wants to do class action, I think we should try it, because right now we're in unprecedented times. We should try this. It's just that the Court of International Trade has always been a very individual court. It's different. It's just a different court than the other courts. But I don't think that should prevent a class action suit. So I personally would love to pursue a class action suit, but we'll see.
We will keep you updated on these developments as well. Maybe let's do a last one. I think you made it clear in your presentation, but maybe just as a final wrap up, what is now the status of the trade agreement between US and EU? Are the max of 15% for importers from the European Union still in place, or is it now MFN plus the 10% section 122?
It is now MFN plus 10%, because as I said before, the agreement has not entered into effect. We haven't even seen the text for the EU agreement. Right? We've at least seen the text for those other 8. Certain provisions have been implemented, but the agreement itself never entered into effect. So, I mean, it's a bad deal. If your MFN was 10% and you then only had a 5% IEEPA tariff, now you're paying that 10% plus another 10%. So your rates have gone up by 5%. That's why the EU held off approving the deal, because it's like, we made these commitments and now you've changed the terms. We're not going to, why? No, why should we approve it? So yeah, it's for some companies, it's better. And if your tariff were only 2% of your MFN and you had 10, now you're paying 12 before you paid 15. So it just depends.
Plus, just a short comment to add on the side, like all the other sections, like section 232 are not affected hereby. So If you're like subject to 232, for example, steel and aluminum, that's a whole different story. But in general,
Yeah.
it's the 122 plus the MFN, so 10%
Right.
plus. Exactly. Well, Nicole, being cautious about your time. Time progresses so quickly, so unfortunately we don't have the time to tackle all of these questions live on air at the moment. We'll try to do our best to tackle the questions after the webinar, which we have here in the chat together with you, Nicole. Thank you for being available after the webinar for us as well. And yeah, thanking the audience for a lot of questions. We can see that this is highly relevant, and we can yeah, say bottom line that well, 122, 301, 232, whatever the legal basis is, the tariffs unfortunately are here to stay, and that also the midterms will not affect this dramatically, we assume, as of now. Yes, thank you very much, Nicole, for being our expert today, and thank you so much for your valuable time today on this webinar. Let me just finish with one further suggestion before coming to the final of this webinar. This might be a helpful source for you following the very volatile situation. There are many sources out there, but make sure to stick with the primary sources when it comes to latest and actual information out there. I've pulled up, or I've summarized 3 or 4 actually bullet points here. First and foremostly, the White House page. This is where the presidential actions like executive orders and proclamations are being published here. So by reading that, you will see what's about to come. The Federal Register is the official gazette of the US government, similar to the Amtsblatt in German language, where legally binding rules will be known to public. So that's where you see when an action is in effect bindingly. And last but not least, we talked about this, the CSMS, or Cargo Systems Messaging Services, the webpage run by the CBP, the Customs and Border Protection, where guidance for importers will be provided. And last but not least, the only German language page on this slide, which is not a primary source, obviously it's a secondary source, but we try to be as precise as possible in German language when it comes to latest and actual tariff news and what's valid for your corporate. Yes, with that, let me close today's webinar. Thank you, Nicole, again for your time, and thank you for the audience and for the excellent questions. We know this topic is sometimes difficult to digest, but we hope that today's overview helped you to navigate through the current situation. And obviously, we will be here for you as well in the future to tackle your questions. Please feel free to reach out to either of our 2 offices in Washington, D.C. or in Atlanta. In Washington, me and my dear colleague, Teresa Weiss, we focus on trade policy and tariff-related questions, and our dear colleague in Atlanta, Angelika Heitzmann, she's dealing with customs and import-related questions, where both or all the 3 are awaiting your emails, your calls, or your texts. So if you have further questions, please make sure to contact Advantage Austria in Washington or in Atlanta. And with that, I would like to say thank you on behalf of our teams from Advantage Austria. Thank you for joining us today. And we wish you all the best and a very productive rest of this week.